Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% or 51 voters as against the constituency average, but I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them, if you don't mind. Let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery treating and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offense of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody, unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for a finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. It was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof. The names, some of which were provided, their formal designations, the offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the same, the court was unable to find in favor of the petitioner, the same on even the assisted voters. Because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on.
The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed. And directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected Member of Parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my Lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with, and therefore, my Lord, we are making an application for expeditious provision of typed proceedings, the judgment of the court, and the decree accruing therefrom. Your Lordship, the reason for the appeal is, my Lord, that this might be the only time the certain issues will be clarified by the Court of Appeal, most importantly, the question of the alteration of the voters' register. And, my Lord, since I am not making an appeal before you, would wish to make the Court of Appeal pronounce itself. Number two, Your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. My Lord, we have listened to you and the judgment, and we note that the judgment itself does not caption the entire report as reported by the Deputy Registrar, and most importantly, in respect to ballot box number 35, and the 212 votes that were cast in foil paper. We have not heard you pronounce yourself on that, Your Lordship. Would we therefore wish to make an appeal? And then, my Lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my Lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the court.
Yes, my Lord.
So you just annex them and say that the lower court failed to deal with an issue.
My Lord, we will be obliged. Yeah. We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it, my lord.
Okay. Yes, Waduta.
Yeah, my lord, Gerard Waduta, and I thank you for that judgment. My lord, I just have one request. And as we review the judgment, so that then we can see what we make of it in terms of what is the next step. We would just like to make an application for stay of execution on the issue of costs, because we know we have money in court.
Yeah. Go ahead.
Yeah, so that, my lord, the issue of costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought. So that then we can make the appropriate application, if any, upon taking instructions.
Okay.
So that, my lord, as Mr. Ndebojiro mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options.
All right.
That's all.
Thank you.
Yeah, I've been informed that I seek 45 days.
45 days.
45 days.
I think you have 30 days actually. I think, well, yeah, he's asking for 45.
Yes, I hear you, my lord.
Yes.
We would be opposing the request for stay, my lord. There is no indication upon which such a stay would be predicated, my lord. No appeal has been filed as yet.
Yeah.
Even the costs have not even been ascertained. My lord, on the second issue, the IBC takes note of the issues you have raised, and they welcome the report which you will be extracting and sending them from this judgment, my lord, which is going to inform the improvement in terms of how they conduct their affairs and how the elections can be improved better. Otherwise, my lord, on behalf of the electoral body...
Let me summarize it.
Yes, my
like
lord.
This.
Yes.
Just sit down. During the hearing of the case, almost without exception, every IBC officer who gave testimony asked, did you report? They also said, was this outside the polling station? Did this occur outside the polling station? I gave a long introductory discussion about the powers of IBC because it is important for IBC to remember that during or in connection with anything to do with elections, IBC is the policeman of Kenya. It's not the Kenya police. So that you cannot wring your hands and say it was not reported, we don't have an OB. No complaint was made. You have seminal powers, IBC. You have powers as a commission, even to investigate. You just need to read the newspaper. You hear something occurred, you run. Just like the Kenya Revenue Authority, when they hear ching, ching, ching in your mobile phone, they come running. That is how ABC is supposed to operate under this constitution and the laws. So that is one of the big areas I'll be discussing in the recommendations. In India, it is clear that IBC behaved, sorry, not IBC, the Electoral Commission there behaved the way IBC behaves today. They changed. They became proactive. The code of conduct is enforced in India. And in fact, in India, the petitions are very, very few. I was there myself, personally. There are hardly any petitions because IEBC does its work. Yeah.
My Lord, while you're still on that.
No, this is not part of the judgment.
That's correct, that's correct, my
we
Lord.
have a
It's also my
post,
observation. And my Lord, the reason why we would wish to have some of these issues clarified, would not wish, my Lord, even to disturb that kind of finding, because, my Lord, this is the first time I've had an election court making such kind of pronouncements in respect on how the IBC is supposed to conduct. So, my Lord, even when you hear us making an appeal, we just want to make sure that we buttress some of those issues that you have said in your judgment.
but you will notice that in discussing the powers of IEBC and its authority, this was not in respect of an issue for determination. So all that is mostly, what we call it, what, obiter?
No, it's not obiter.
What is
You're
it?
supposed to pronounce yourself in a manner that the law also speaks. It's not obiter.
All right. Anyway, you will take the judgment to the next court. But what worries me is what I see every day happening, because we are all Kenyans. We see things that occur. We hear when there's an election petition or an election, in any part of the country. It's reported in the newspapers. There are clips from all sorts of places. We don't believe everything, but we are able to get the general mood of people. And that mood, although we cannot represent it in our judgments, it has to come through evidence. Parties have to bring the evidence. Even all this bribery, I've actually seen myself clips of people standing in a line being given money. It's just that nobody takes them to court. But these are things that IEBC has the power to curtail, even under the Constitution. Under the Constitution. And the DPP cannot say that he's the only one who can investigate or prosecute, because the powers have been given under the Constitution through a statute for prosecutorial. So one of the things I'll be proposing is the setting up of an inspectorate of IEBC. That's one of the things I want to recommend. I can't recommend those things here because it wouldn't make sense. But there must be some kind of inspectorate. I don't know how Kenya Revenue or Kenya Anti-Corruption Commission, how they do it. But however they do it, they seem to be fairly effective. That's what we want with IEBC, because the Constitution guarantees us a free and fair election. It guarantees Weveti that when she is going to her polling station, nobody is going to sumbua her. No masumbuko. I'm going to vote, and I'm going to vote for who I like. And if I take your money, I will still vote for who I like. Okay. So that's the key point. Sorry. Anything else?
Maybe just on the obiter. Yeah. As I thank you for the way you have conducted the proceedings and the efficiency. Also to bear in mind the timelines which the respondents are really given to respond to this such a bulky election petition. A single 7 days.
Yeah.
Some of the irregularities, my Lord, which may go unexplained, could be because of this scarcity of time, my Lord. Otherwise, it's to say that yes, my Lord.
Did you put it in the report?
I did.
You did?
I did, my Lord.
Okay.
Otherwise, we take a lot of lessons as IBC, and we appreciate you a lot and your entire staff. Thank you very much, and even to counsel who appeared in this matter.
Okay.
Yes, my Lord, the fourth correspondent, we appreciate the announcement, except on one issue. I think Mwongo has taken the bulk of the cost. Perhaps we'll have a discussion outside the court. We can share something with us. Otherwise, my Lord, we are happy in the manner in which you have conducted these petitions. We are also happy with the judgment that you have pronounced today.
Of course you would be.
Yes, naturally.
Yeah.
But on my part, I'm most impressed by the time you've taken to give IBC the teeth that it seems to have lost.
Yeah.
I think for me that's a very proactive judgment which will clean up the electoral practice in this country.
Yeah.
Otherwise, thank you very much from the fourth correspondent, and we need to congratulate you. But my colleague has something to say. Thank you. Lord, we welcome the well-reasoned judgment of the Honorable Court, which has really shed light on very pertinent issues that arose from the petition. And our for the respondent who is present takes this opportunity to extend a hand of friendship to the petitioner. Now that the court has decided, and as we are aware, politics and democracy in their very nature are competitive. But it takes a wise soul to accept the electoral and judicial outcome in straight, and I recognize that Mr. Giro is already in agreement with the position taken by this court, and indeed he says he wishes to go to the Court of Appeal to buttress the decision of this honorable court. So we are of the view that Mr. Giro may want to take into consideration the will of the people, the constituents of Mbeere, who would desire that going forward, the game moves from the court to the ground in terms of development programs, in terms of rendering of services, such that no more attention will be devoted to court proceedings. Therefore, the respondent has had a lot of distraction during the time when these proceedings were in progress. He had to shuttle between the constituency and the court, and that has unduly impacted on his ability to fulfill the promises that he made to his constituents. So we would be glad if this matter can rest at this stage. We continue to celebrate the wisdom of this court together with the petitioner, and it will be good for all of us. Because sometimes you win, sometimes you lose, and even then, the next election cycle is just 1 year away. And I'm sure our client, for the respondent, will be willing to make some considerations which would be favorable to the petitioner, depending on how the petitioner takes the outcome of these proceedings. Now, with regard to the prayer for the cost, we'll also be making an application that the amount deposited as security for deposit be released to the respondents.
Are you making that application now? Because I've already given a stay of 30 days, so even if you make the application, it will not affect the stay.
Very well, then the amount can be released to the respondents on the 31st day. That's all.
Judge, we thank you for the detailed judgment and the way the court has conducted this particular petition. I as a Gabriel Njiri, I'm the senior most for the petitioner, and on behalf of the petitioner, we thank the court for the judgment. At the same time, to remind my colleague, Mr. Kamodo, that the petitioner and the four respondents are friends, and they will remain as friends, besides their political diversity. One issue, we would like the court to give directions on the electoral materials. My colleague had requested me to mention that, and also the keys that we are holding for the safe room going forward. We shall be inviting Judge Karodoi to thank the court formally on behalf of our team.
I forgot to say anything about the electoral materials. Obviously, they will be returned, but let that come through a direction that I'll give the DR, which will, so I'm just saying directions on electoral materials will be given to DR to effect. Yes. Thank you for reminding me.
Thank you, my lord. I noticed today the role of the bar saying thank you to the court has been taken up by several people. I think it's what they said, that success tends to have to give others. But on behalf of the bar, we would like to say thank you for the way the matter has been conducted. On the end of the petitioner, we may not be happy, but we are grateful. We have been handled, managed, treated with utmost professionalism. And I think that no one sitting on this side can take it away from this court. And even next time, if there is, we will be more than happy to end up in this court. And we also hope that all the issues that we picked up for recommendation, that they are going to be acted upon to make the resolution of electoral disputes to be enhanced. And that is why I wonder, looking at the spirit with which we have gone, I was of the thinking that Mr. Kamotho, or Dr. Adrian Kamotho, should be looking forward to a robust appeal process, which will actually even make these issues clearer, instead of offering an olive branch, while the petitioner is actually going after the whole tree and its fruits. So we hope that we will be fully facilitated with everything that we have asked for. And we wish the court all the best going forward. And thank you very much.
Thank you very much, Council. I take that with a lot of appreciation. You noticed I started by appreciating and acknowledging you all, because I didn't know what might happen after I make the final determination. And I didn't know whether there is enough security. No, thank you very much, Council. I have also enjoyed myself during this whole exercise. And you say when we do it again. I hope we don't. By then, I think I should be an elder doing an alternative justice system next year. But thank you very much, all. I appreciate you. Have a good afternoon. Oh, I have not used my gavel, and somebody complained. So let me use it today. Let me use my gavel because it has not been seen to be used. The proceedings are closed. May we stand? Thank you very much. You're most obliged.
You're most obliged.